our esteemed and dearest listeners, subscribers, and followers of Law Ascent. Welcome again to Classroom here in the University of Legal Literacy. This is where we do our business in terms of sensitizing the society and ensuring that the malady of legal literacy is cured. And that is what we do here in Ascent Radio. And welcome another day to another interesting and exciting day of exposition into what the law provides. I remain your host, the Dean of this Faculty of Legal Literacy in the University of Law Ascent, Barrister David Njoko Ono. And today I will take you on a smooth sail in the world of wisdom and legal. We'll take you from the fountain of legal wisdom, where we are going to be discussing powers of state governors to probe their predecessors. Did you hear that? Powers of state governors to probe their predecessors. Remember, after the May 29th inauguration 2023, many governors came up and started making pronouncements, setting up committees, task force, so as to investigate actions and activities of their predecessors while in office, during their stay in office there. It was not strange to political followers and analysts and political enthusiasts within the Nigerian circle, because students of history will always remember the days of Awolowo and Akintola in the 60s, or the ways of Ajasin and Mr. Akin in the old Ondo State in the early 80s. So the bickering between successors and their predecessors in office in terms of state governors is not new. But what was captivating in this instance after the May 29th 2023 inauguration of state governors is the manner and approach in which the probing took its shape this time around. Remember, like in the case of Zamfara, Governor Dauda Lawal decided with immediate alacrity, swept into action. The first point of call was the home of the former governor, Bello Matawali, where over 40 cars were said to be confiscated, all in the name of probing the former governor, Bello Matawali. You equally remember that in the case of the heated one now, which is that of Kano State, by Governor Abba Kama of Kano State, who went into demolition spray in Kano State, demolishing several properties which we are purported to have been built on public land. The question now is this the mode, is this the procedure provided under the law for us to go about probing predecessors by current or sitting governors? And that is the essence of our discourse today. So the first point of call is, where does the governor amass his power? Or where does his powers endures? Or where does his power generate? He generates his powers, the legal power now, to investigate or probe his predecessors. I believe you must have been wondering, because the usual agency that is in charge of probing governors is either the Economic and Financial Crime Commission, the EFCC, or the ICPC. But this time around, it is governors themselves probing their predecessors, having the police to confiscate properties, or setting up task force to demolish properties, or setting up task force that goes about trying to seize properties owned by private individuals which were purchased from the previous government, or they are either laying off workers that were employed into the civil service just few months or few days to the exit of their predecessors. So all this, where are the legal backings for all this? And that is the cause for our discussion today. So we start off, where does the governor, their powers lies in terms of probing their predecessors? Now, the position of the law is that for a governor to have the powers to persecute or to probe his predecessor, that states must have the Tribunal of Inquiry law, which is a replica of the Tribunal of Inquiry Act in Nigeria. Now, what the Tribunal of Inquiry law provides is that law that grants the sitting governor the right to set up a committee or set up a panel. That is the words of the law, to set up a panel for the purpose of investigating and fact-finding in the activities of public officers within the public service. Now, that panel must be set up by way of an instrument. And what is an instrument in law? An instrument simply means a legal document authorizing the doing of a thing and stating how they should be done, the methodology, and then the scope of engagement by whatsoever panel that is to be set up. Now the question is, if a panel must be set up to probe, or can the governor probe without setting up a panel? Now, the answer to that is that the governor must set up a panel for him to be able to probe. The governor cannot probe himself. So by that, we look at the actions of certain governors, like for example, the Governor Caleb Motwang of Plateau State, who set up a task force for the purpose of recovering properties that were auctioned by the Solomon Landlord-led administration prior to his inauguration in May 29, 2023. Now, the words of the Tribunal and of Inquiry Law of Plateau State state that the governor must set up a panel, not a committee. There is a difference between a panel and a committee. Now, a panel is set up by instrument, by a legal document signed by the governor, wherein it states the names of the members of that panel, the chairman of the panel, the quorum of the panel, the timeline for which the panel is to bring out its report, or what we call white paper in law, and then its terms of reference. Now the question is, the task force set up by Barrister Caleb Motwang of Plateau State, was it initiated by way of an instrument? The answer is no. Was it composed in such a way that it has quorum and terms of reference? Yes, there may be terms of reference, but no quorum. The terms of reference was recover all auction property sold by the immediate past administration led by Governor Simon Lalong for the purpose of recovery. So if you have terms of reference, but there is no instrument setting you up by the governor, then you don't constitute a panel, and as such, it is an illegal task force. Because that task force is now taking the place of the judiciary. It is only the judiciary that can come up with a verdict for which will now confiscate a property of anybody. Not even, by the time we get to that very bridge, we'll cross it. Not even the panel set up by the governor under the Tribunal of Inquiry Law of various states can enforce these verdicts on illegal acquisition of properties of the state. The best the governor can do is to use the white paper report of the panel to ensure prosecution of the persons that have been indicted by the white paper. So the governor cannot on his own execute the verdict or the report given by the panel, or in this case of Plateau State, by the task force. Another example is we look at the example of Governor Abba Yusuf of Kano State, who went about on a demolition spree, as I will call it, pulling down buildings, structures that have been erected in alleged government property or public property. The question the law asks is, the question to ask here under the law is that, are Nigerians entitled to the ownership of properties under the Constitution? The answer is yes. Section 43 of the Constitution provides and ensures and guarantees the right of Nigerians to own property anywhere in Nigeria. The question now is, these properties that were allegedly sold to private individuals, were consideration in terms of monies, were they paid for the acquisition of these properties? If money exchanged hands, the next question is, did the governor or the government of the day, as at then, did they execute a valid certificate of occupancy and issued it to the said buyers? If that yes is the answer, then we come to the conclusion that the buyers or those in possession have lawful possession of those property, haven't acquired them lawfully from the government who were in power as at when they acquired the property. And as such, it's not in the place of the current governor to now, by way of using executive fiat, to now confiscate or demolish or repossess the properties that has been acquired by private individuals from the hands of the government. It's not in its place at all. Now, the question now we ask, the next question we ask ourselves is, what is the scope of the panel of inquiry when set up by the government? We have already established that under Section 1 of the various Tribunal of Inquiry laws of various states, it is provided that the governor has powers by way of instruments to set up a panel for the purpose of investigating and fact-finding of activities of public officers within the public service. Now, the officer within the public service, the scope of their powers is to investigate any officer in the public service, number one, of the state. Number two, to probe any officer in the local authority in the state, maybe a local government or a department or an agency of the state. They have the powers to probe them. Then to investigate and come out with the truth, just like a Truth and Reconciliation Commission, with respect to chieftaincy tussles within the state. Panel of inquiry has the powers to do so. Okay, when the governor decides to set them up by way of an instrument, not by way of executive orders. The governors cannot, by way of pronouncement, set up a task force or set up a committee for the purpose of probing their predecessors and recovering properties. That is not the position of the law. That is tantamount to an illegality, an unconstitutional act done by governors if they do so. And we have used the example of Governor Caleb Motwang of Plateau State and Governor Abba Yusuf of Kano State with their recent activities. Now the question then to ask, the next question to ask is, to what extent or to what effect is the verdict of a panel of inquiry set up by the city governor to probe their predecessors in case the panel report comes out negative, that is indicting the immediate past or the predecessor to the current governor? What is the position of the law? Now, before now, the position of the law has been that where anyone is being indicted by a judicial panel of inquiry or tribunal of inquiry, such person will no longer be eligible to contest for the office of the governor of a state or as a member of the state or national assembly or to be appointed as a minister. Now, that was the position before 2014. Okay, now before the 2014 amendments, which is the third alteration to the current 1999 constitution, the position has always been that once you are indicted by a panel of inquiry or a tribunal of inquiry set up by the state government of the federation or the government of a state, then you are no longer eligible to contest for the office of governor of a state or member of national or state house of assembly or to be appointed as a minister or commissioner. That was the position. But the position changed after 2004, such that that provision has been deleted in our constitution. So, the purpose of the report, indictment report by a valid panel of inquiry set up by the governor for the purpose of probing his predecessor, the effect of it is that it's only a fact-finding report for which can be relied upon by either the Economic and Financial Crime Commission or the ICPC, who are the federal agencies saddled with the responsibility of investigating and prosecuting indicted officials, public officials, who have been indicted by way of investigative reports. That is to say, while the panel has the powers to investigate, they don't have the powers to prosecute. But the EFCC and ICPC has the powers to investigate and prosecute. So the best the panel can do is, after production of its white paper, is to transfer that white paper to the office of the chairman of EFCC for purpose of prosecution or the office of the chairman of ICPC for the purpose of prosecution. Otherwise, that remains a report that is only going to serve as public embarrassment to the predecessor and nothing more. Now, the Supreme Court in 2022 went further to establish, in the case of Amechi against government of Rivers State, that an indictment by a judicial panel of inquiry is nothing more than a fact-finding report for which has no effect in law as it is neither a court, that is the panel, judicial panel of inquiry is neither a court nor a tribunal for the purpose of adjudicating and prosecuting public officers. So, in that, let me just put the scenario. In case of the judicial panel of inquiry led by Justice Omereji, that's set up by Governor Nyesom Wike, the then governor of Rivers State, to investigate the activities of Right Honorable Rotimi Chibike Amechi, the predecessor to Governor Nyesom Wike as governor of Rivers State. That judicial panel of inquiry brought out a report in 2017 which indicted Governor Rotimi Chibike Amechi. Now that report was now used first in 2019 for the purpose of stalling the confirmation of the appointment of Right Honorable Rotimi Chibike Amechi as a minister designate by the president, on the grounds that, having been indicted by a judicial panel of inquiry, he is no longer eligible for appointment as a minister. Now, this was under the erroneous belief of the existence of the old law, and those persons who took that up that matter were not aware that that is no longer the position of the law, that the law has changed to the effect that the indictment of a judicial panel of inquiry has no effect whatsoever in law. And as such, the Supreme Court, upon the show of interest by Right Honorable Rotimi Chibike Amechi to contest the presidential election primaries of the All Progressive Congress to become his presidential flag bearer in 2022. These persons brought up this issue, trying to bring up the issue of him being indicted and as such no longer eligible to contest for the highest position of the country, which is that of the office of the president. Again, under the erroneous impression that having been indicted, he is no longer eligible. The Supreme Court, giving its verdict, now stated clearly that panels of inquiry, not having the powers of the judiciary, even though manned by ex-judicial officers, cannot take the place of the courts. And its verdict, whether by way of indictment or by way of exoneration, has no effect in law, except the effect of a report of investigation after investigation has been concluded, for which can be relied by either the EFCC or ICPC for the purpose of prosecuting the indicted public officer. So, the question now is it that the governors that are setting up committees, task force, and tribunals for the purpose of probing their predecessor, they are not aware of this current position of the law? They may be aware, but the thing is that sometimes mischief plays in. The mischief of wanting to paint the predecessor to be someone of corrupt character, by way of trying to paint the image of their predecessor to be not one that is a good public servant or a corrupt person, for which he is not fit and proper to stand for further political positions moving forward. Now, having established this, what is the way forward for current governors wanting to reclaim properties which are believed to have been unlawfully sold by their predecessors to their cronies, proteges, and friends? Now, the only way forward is that these governors, rather than setting up these panels of inquiry and going by way of probing and indictment, should take up this matter with the Economic and Financial Crime Commission and ICPC, which is a body saddled with the responsibility of investigating and prosecuting public officers, and then go through the way of the courts to reclaim these properties if they have concrete evidence that they were not properly transferred, the title was not properly transferred from the government to private individuals. And this will be better other than going on a demolition spree or going by way of setting up task forces and invading the private residence of their predecessors for the purpose of classification of their properties. Because the task force, nor the tribunal, nor the committee are not courts, and as such, their verdict cannot be said to be that is enforceable, just like the verdict of a court of competent jurisdiction. I believe with having set up this, stated all this, you are now abreast with the position of the law that number one, governors has the inherent powers to probe their predecessor, but doing so they must do that by way of an instrument, which is a legal document signed by them, setting up a tribunal of inquiry or a judicial panel of inquiry for the purpose of investigating their predecessor and coming up with a fact-finding report, which is now a white paper. And after this white paper has been published, it can only go through the way of either the EFCC or ICPC, and then the way of the courts also, for there to be a full indictment of the public officer or their predecessor, and then they can reclaim whatsoever public property that is allegedly to have been stolen by their predecessor. Then number two, that even where the panel of inquiry or tribunal issues out a report, that report remains a fact-finding report and not an indictment for the purpose of enforcement against their predecessor. So they cannot go ahead and begin to confiscate the private properties of their predecessor, just as what we had with the case of Governor Daula Lawa of Zamfara State and his predecessor Alhaji Bello Matawali, which the court, the Federal High Court, has already stated that all 40 vehicles that were forcefully taken from the home, the private residence of Governor Bello Matawali, has to be returned to him, because the task force set up by Governor Dauda Lawa is not a court. And even though it has indicted Governor Bello Matawali of illegally confiscating the governor's or government vehicles, that is not a judgment of the court which has the force or the toga of enforcement under the law. With this, I believe public officers are now well abreast that they cannot use the report of a panel of inquiry for the purpose of probing their predecessor or indicting their predecessor. They cannot use that report to store the political future of their predecessor or any other person, as the effect of an indictment by a panel of inquiry remains a fact-finding report and not one that is to restrain the indicted public officer from holding future political offices, because that was the proposition under the old law, but not under the current dispensation, which is the 5th alteration of the 1999 Constitution as amended. I believe with this we have well covered. We have well covered the grounds and this topic, and you are well now abreast with the position of the law. As usual, we will always want to get your feedback, comments, and suggestions. And you can do that by leaving a comment or leaving your feedback at the comment section of whatsoever streaming platform you are listening to us. And definitely, we will give you the promptest of responses that you will ever think of. Until we come again your way next week, stay blessed, remain safe, and keep praying and trusting God for a better Nigeria. From us here in Asset Litigation, and for me, your host, Barrister David Njoko Onu, I say bye-bye.